Today on Law Weekly, we track some of the major legal events of the year. We also have a recap of the top legal stories of the past week. And on our interview segment, we chat with Mr. Wahab Shitu, a legal practitioner and lecturer at the University of Lagos. That's the lineup on this episode of the program. Hello and welcome. I am Shola Sheyeli. Let's begin with the review of the judiciary and some of its activities in 2015. 2015 started on a not too pleasant note for the judiciary. Like it happened in 2014, judicial staff workers again downed tools and embarked on an industrial action to force the executive to implement a verdict of the Federal High Court Abuja, which declared as illegal, unconstitutional, null and void the control and disbursement of funds earmarked for the judiciary by the executive arm of government. The action, which started in January in both federal and state courts across the country, lasted for several months in some states, simply because some argued that the executive arm of government in those states continued to demonstrate an unwillingness to respect the financial independence of the judiciary. After the intervention of some critical stakeholders, the workers resumed, and the first challenge the courts were confronted with were the pre-election matters which could have affected the conduct of the general elections. There were suits instituted to contest the eligibility of both President Muhammadu Buhari and former President Goodluck Jonathan. There was also a suit challenging the election itself and another disputing the use of the card readers. After the courts dispensed with these suits, the elections held and were judged by many observers to be largely fair and credible, a development that led to the decision of former President Goodluck Jonathan to concede defeat to his challenger, and for the first time since the return of democracy, there was no petition filed to challenge the presidential elections. These, however, did not stop other candidates at other levels of the elections from going to the tribunals. Aware of the potential challenges ahead, the Chief Judge of the Federation, Justice Mahmood Mohammed, at every opportunity never failed to urge judges to guard the independence and impartiality of the bench jealously.
I wish to address the vexed issue of judicial corruption. This is because allegations about corrupt judicial officers and staff now make headlines, news, or on more frequent basis. With each allegation that passes, the need is ever present for the judiciary to address this issue, and I feel it necessary to once again do so.
In anticipation of the election petitions, Justice Mohammed in February swore in 242 judges who were selected to serve on election tribunals. The tribunals have since concluded their jobs, and the legal battles have shifted to the Court of Appeal and the Supreme Court, which is the terminal point for governorship election petitions.
They have conducted their jobs within time, and that's very good. It's the idea of an election petition lasting 3 years into the term of the incumbent governor who may be deposed later has not arisen. I give that to these tribunals.
Most of the judgments that we have seen have been judgments that are actually in compliance with the provision of the Electoral Act. We have also seen judgments where there is need for you to also question the rationales of some of those judgments. However, largely, I think nearly over 70% of judgments that I've seen so far have been in accordance with the law.
The bench got a boost in November when President Muhammadu Buhari approved the appointment of 30 new judges for the Federal High Court on the recommendation of the National Judicial Council, NJC. In the same month, the President approved the compulsory retirement of a judge of the Federal High Court, Justice Lambo Akanbi. The judge was retired after the NJC investigated and confirmed that it violated the Code of Conduct for judicial officers. For the lawyers, the umbrella body, the Nigerian Bar Association, jettisoned its 17-year-old electoral guidelines, and at a well-attended general meeting of all 110 branches of the association, led by the president of the bar, Augustine Alege SAN, members endorsed the e-voting system for the bar elections. This means that all Nigerian lawyers who have paid annual practicing fees can now vote with effect from the 2016 elections. It will be interesting to see how this would impact on the bar elections in the new year and how all the different interest and regional groups in the bar will be accommodated. One good thing that has happened to the judiciary this year is the passage and signing into law of the new Administration of Criminal Justice Act 2015. The act, which is operational in the courts of the Federal Capital Territory and other federal courts in Nigeria, is to ensure that the system of administration of criminal justice in Nigeria promotes efficient management of criminal justice institutions, speedy dispensation of justice, protection of the society from crime, and protection of the rights and interests of the suspect, the defendant, and the victim.
Lawyers, defense lawyers, seem to raise objections, seem to want to take long adjournments, and the pretext that they have so many other cases they're appearing on, pretext that they're traveling for medicals, and the pretext that even the accused will be traveling for medical.
That law is meant to actually check excesses of lawyers who are in the habit of always looking for stay of proceedings because they want to compromise the system.
No corruption case was concluded by the courts in 2015. The dispute between the executive and the legislative over the amendment to the constitution was also not resolved. Also pending is a dispute between the federal and the state governments over value-added tax and the sovereign wealth fund. 2016 brings with it the expectation that these issues will be resolved. Many Nigerians are also hopeful that issues of prison congestion, the high cost of litigation, delays in court cases, how to shield the judiciary from political influence, and reform in the process of appointment of judges will also be addressed. Other cases which the courts must decide in the new year include the issues surrounding the Kogi state elections, the Saraki and the Code of Conduct Tribunal suits, the new corruption cases initiated by the Buhari administration, among many others.
I would love to see a more vibrant judiciary. I would love to see a more effective judiciary. And I would love to see a more improved in terms of technology judiciary. Our judiciary should be properly equipped. Our judiciary should be well funded by government.
Lazy, corrupt judges, inefficient judges, ignorant judges, they should be flushed out. And then, of course, the speed of administration of justice should increase. And there's no way you talk about judiciary without talking about the lawyers too.
The attitude of lawyers must change for these cases to move. Then, with respect to the bench, most of the time, these days are given. Only for you to come and say the judges have gone to workshop, judges conference. And I feel these are things, the timetable should be there within the year, so that within the period of this conference or workshop, this will not be given. And once those days are vacated, then you have another 2-3 months adjournment. That's why you see most of these high-profile corruption cases, they don't finish, they don't come to an end.
The judiciary definitely has its work cut out in 2016. As it has always done, Nigerians expect that the judiciary will continue to strive towards the realization of a judicial system that serves to dispense justice no matter whose interest is at stake.